We're going to continue to talk about defenses, but we're going to switch gears. What we were talking about with self-defense, defense of others, defense of property, those things come under the justification umbrella of defenses. We're now turning to excuse, those defenses that come under the umbrella of excuse. So we are focusing on the actor, not the conduct itself like we did with the justification. We're talking about the actor. And the first one we're going to talk about is the insanity defense. In most states, it's not referred to as insanity. The term, however, is used to describe it because that's what lay people who would be the jurors understand insanity. They were insane at that time. In New York, we refer to it as there was a mental disease or a defect that caused the individual to do what they did. And most states have some interpretation of that. It doesn't say, oh, the person was insane. But when someone successfully asserts the insanity defense, my question is, so what happens? Oh, they were insane at the time they committed the crime. So we'll let them off. They're acquitted, not guilty. That used to be the case until the case involving the attempted assassination on Ronald Reagan. I want to say, the defendant keeps escaping me, but I think his name was McKinley. So if you're doing that case, this is going to be what most of it is going to circle around and what has occurred or transpired after that case involving this defense. But no, not anymore. The majority of the states rule if this was a successful defense, something else would happen. This is kind of like an imperfect defense. The defendant would have to undergo a mental health evaluation, and it could result in being institutionalized for a period of time or for the rest of their life, but until some psychiatrist or expert deems that they're no longer insane. This is a very hard defense to prove. It's hardly ever successful. However, if you do a Google search, all of the cases where it was successful will come up, and there have been quite a few overall, but in reality, it's very hard to prove. There are 4 states that do not recognize it: Montana, Utah, Kansas, and Idaho. But that doesn't mean that a defendant couldn't argue because of their mental incapacity or their mental illness or some mental disease that they aren't entitled to a lesser sentence or some other punishment. It would just be attack on that element of criminal intent. They didn't have the ability to establish the intent because of their mental health defects. So it would be more of a failure of proof argument in those 4 states. So criminal defendants who do suffer from any sort of mental illness, what happens is they have to produce evidence of that. And usually it comes from a medical professional, an expert who can speak to the disease itself but specifically to the defendant's disease. Sometimes it's obvious from the defendant's conduct that there's some sort of mental illness, but it's very hard to distinguish in reality and in the courtroom legal insanity and medical insanity. They are kind of 2 different aspects to distinguish. Most individuals who suffer from some sort of mental illness, and let's take PTSD for instance. Somebody who suffers from PTSD certainly knows the difference between right and wrong. So it's not as simple as that question, knowing from right from wrong. It's whether or not the disease itself brought about the conduct. So let's talk about this. There's 4 of them. There's 4 insanity defenses, types of insanity defenses that are recognized throughout the various states. There's the McNaughton we're going to talk about, the irresistible impulse, the substantial capacity test, and the Durham test. And I am going to, just to give you a heads up, I'm guessing my lecture will be short. However, if we were doing this in the classroom, I would actually be showing you some videos relative to each one of these and how they played a role with a specific defendant. I am going to link those videos in. I'll mention them as we go along, but they're part of Moodle, and you'll see them in the list as the video. So hopefully you will watch them relative to their specific insanity defense. So let's talk about the McNaughton insanity defense. This is also kind of called the right-wrong test. This is the most common one in the US. It's also the oldest. This was created back in England in 1843 after Daniel McNaughton, who was the first defendant to raise the issue, and successfully. This defense is cognitive and focuses on the defendant's awareness rather than the ability to control conduct. So this is key. Defendant's awareness, not his ability. And we have ability to control his conduct. We have two elements. The defendant must be suffering from a mental defect, or defect of reason, not being able to reason, or disease of the mind. Mental defect. That's how we define mental defect. Defect of reason, disease of the mind. At the time he or she commits the criminal act. Not before, not after, at the time. And that because of that mental defect, the defendant did not know or appreciate or understand, whatever the word is in that jurisdiction, either the nature and quality of the criminal act, or that the act was wrong. Who has the burden to prove this? The defendant. The defendant has the burden of proving this. Some examples: psychosis, schizophrenia, paranoia would be examples. Certainly there's lots more. Let's talk about the terms. The terms slightly vary from jurisdiction from jurisdiction, but that doesn't mean that it changes this test. Just using the words like know and appreciate, understand, that would be the word that would change. So the first element is what is meant by know or understand, because number one, a doctor will show, psychiatrist will show that the defendant suffers from a mental defect. And they have to also show that at the time of the act, the criminal act, that was playing a role. But then the next step is, because of that mental defect, the defendant did not know or understand either the nature and quality of the criminal act, or that the act was wrong. So what does know mean? Again, it's going to depend on the definition by the jurisdiction. Did not know, understand, or appreciate the nature. That's another word that gets used. Know, understand, to ascertain the basic level of awareness under the circumstances. That's the definition we're going to use. So if you see know or understand, that means ascertain the basic level of awareness under the circumstances. If you see appreciate, what's meant by appreciate, the defendant did not appreciate either the nature and quality of the criminal act. Analyze the defendant's emotional state. The character and personality might be relevant. So that's what's going to be analyzed by a trier of fact. What was the defendant's emotional state? Could they appreciate either the nature and quality of the act? And nature and quality of the act, the first part of this, or that the act was wrong, the last part of the element number 2. Nature and quality of the act. This is a lot harder to prove. Basically, the defendant was oblivious to what he was doing. That's a big step that has to be proven. Didn't know what he was doing. How about or, which is the one that's put forth more in a defense, not so much the first one as the second one, that the act was wrong. Did not know that the act was wrong. But what does wrong mean? The legally wrong is aware that the act is against the law, unaware that the act is against the law, and legally, morally wrong. Must also be aware that the act is condemned by society and against the law. So basically, they're unaware of these things. Completely unaware, it's against the law, legally and morally wrong, and that the act is condemned by society. Not all three of those in some capacity or another. Now there are two examples that are cited. The case names are cited in the book, but it doesn't give you much information. I have videos to look at, the Susan Smith case and the Andrea Yates case on this particular defense. The key here is, with this test, is if there is evidence overall in this and when you're looking at these two videos, Susan Smith case and Andrea Yates case, if there is evidence of a cover-up or attempt to hide or an attempt to escape, that's going to backfire on the defendant. It's going to show that the defendant knew right from wrong, and that's going to defeat the claim of insanity under that second element, okay? So for the Monotone test, which is recognized in New York, by the way, this is New York's mental defect statute, you must have a mental disease or a defect of the mind, that's element number one, plus the inability to know nature or quality of the criminal act or that the act was wrong, and that's the key to the Monotone test. Make sure you know all four of these and the different quirks between them. The second test is irresistible impulse defense. This has a home in Texas and Virginia, but it's not, clearly when I tell you those two states, and then I say it's not used by most states, that's obvious. What it stands for is these two elements, and you can see how they distinguish between the Monotone. Mental disease, you need the mental disease or a defect, so element one is the same. It's number two that changes. The inability to know nature or quality of the criminal act, or that the act was wrong, or the inability to control conduct. So they add kind of a third component to this number two and gives the defendant three options under that element. So the question is, does this sound more favorable to the defendants? It is, because it's easier to prove. And it actually does result in more acquittals because it focuses on the defendant's awareness and ability to control his or her conduct. And under this theory, the defendant could understand that the act was wrong, but couldn't control their conduct. The distinguishing factor is between the conduct that can be controlled and conduct that cannot be controlled. There's an example in the book, Lorena Bobbitt case. I don't have a video on that particular one, but the book sets out the example pretty clear, so have a review of that. I was just going to tell you the outcome, but you know what? I don't want to ruin the surprise. It's actually it's sad, but it's interesting. When you first read it, you're going to giggle. But check that case out, and that one falls under the irresistible impulse defense. The substantial capacity test. This is found in the Model Penal Code, and half the states and the federal government adopted this test up until 1982. Hinckley, I was right, until John Hinckley won using this defense. And then the feds, they created a completely different statute that the feds have. And because the John Hinckley case, I believe, was a federal case. And a number of states switched back to the Monotone test in 1982. But let's look at the substantial capacity test. Again, two elements. You have to show mental disease and defect of the mind, and you have to show that the defendant lacks substantial capacity to appreciate the criminality of conduct or to conform conduct to the law. So the difference is that element number 2 is more flexible. It's a flexible standard and relaxes the requirement for complete inability to understand or know the difference between right and wrong. You can understand the legal wrong versus a moral wrong. Substantial capacity, not complete capacity. Just substantial capacity, not complete capacity. And then there's that word appreciate. It doesn't say not knowledge, it says appreciate. Did this defendant have substantial capacity to appreciate? So, and that is, what is the character, emotional quality of this person? I don't have the case name by this one. There is a example that I labeled in the book. I will put a link to it on Moodle. I'll actually have these defenses laid out, and I'll put the subsequent video that goes along with it so you can follow along and see how these operate with a particular defendant. And then the Durham insanity defense. This only exists in New Hampshire. Mental disease or defect of the mind. They all need that one. And the act is caused by the mental disease or defect. And then what happens? It's excused. The conduct is excused. So the problem, or the issue here is defect must cause it, and it has nothing to do with knowing right from wrong. And this is much more difficult to prove, that the act actually caused it, okay? Or that the act is caused by the mental disease. So this one's a little tougher. New Hampshire has it as their defense. There was a very recent case out of New Hampshire. I'm going to put a link to the Gribble case, and I'm going to put the actual defendant testifying on his own behalf, and that's all I have to put up there, and you would probably think this guy's got something wrong with him. But I'm also going to put up his psychologist, or his expert witness, who was not a psychologist, a psychiatrist. So take a look at that. So proving insanity. Who has to prove this evidence? Who has the burden? Does the prosecution have to prove sane, or does the defense have to prove insane? We have reasonable doubt as the burden of proof for preponderance of the evidence. Well, let's start with the presumption. Remember what we talked about with the presumption? You have to start there. That the defendant is presumed sane, just like he's presumed innocent, okay? And the defense is the one, I think I've already alluded to it throughout this video, that has to prove that the defendant is not sane. How do they do that? With expert testimony, because that means the defendant couldn't take the stand and say, I suffer from a mental defect. It has to be proven by a psychiatrist or some other expert who can speak of the defendant's mental illness. Standard of proof, because it's the defense, preponderance of the evidence. Diminished capacity. Let's talk about this. This is different from insanity. Insanity a lot of times ends up, not a lot of times, but it had initially ended up with an acquittal. A diminished capacity is like is the reduction crime, in that you don't end up in a mental institution, right? What happens is if a jury finds somebody not guilty by reason of insanity, it depends on the state, but in the state of New York, how a jury would have to come back if they wanted to conclude that somebody was insane was they would have to find them guilty of the charge. But then they would say, but then not guilty by lack of capacity or by diminished disease or mental defect, whatever the judge writes in the instruction pattern. So what happens is then the judge orders the person to be evaluated, and then they have to go through that process of possibly being institutionalized. With a diminished capacity, we're talking something like the battered woman syndrome, the battered child syndrome, some personality disorder that tends to attack on the criminal intent component. Like let's take the easier of the examples that we've already talked about, the battered woman syndrome, right? So a wife shoots her husband while he is sleeping, and she's trying to claim self-defense when in actuality she had a diminished capacity because she thought that she was going to be in danger yet that day, because for the past 10 years she was in danger every single day from abuse from her husband. It's called diminished capacity. And this is usually used, this is what I was explaining at the beginning, those 4 states that don't recognize it, this is how they get there. States without an insanity defense will use this diminished capacity. To recognize the difference with competency to stand trial and the insanity defense, there is a distinction. The insanity is a mental state at the time the person commits the act, or we'll call it the crime. What was their mental state at the time they committed the crime? Mental competency explores the defendant's competency to proceed to trial. Trial can be delayed until the person regains competency, and then it can start again. They may have committed a crime last week and then was in an accident and ended up in a coma or suffered from a head trauma, or they may have had some sort of mental breakdown, but at the time they committed the crime they were fine. But at the moment they can't stand, they don't have the competency to stand trial. So do they understand? The point is to determine whether or not somebody has the competency to stand trial. The judge will order someone to get an evaluation if it's questionable. We don't do that in every single case, but if there's some question to the defendant's competency, the judge will order a review, psychiatric review, and then hold a hearing to determine whether or not the person can understand what's going on. If it comes back with a report that they're incompetent to stand trial, the person will go to a facility and get treatment until they're released saying that they're competent. If it's something that is ongoing and it's a lower level offense, a court might just dismiss the charge outright. If it's a felony, there's a little bit longer process, but in the end, the judge can dismiss it. And then later on, if the person is deemed competent, the DA can bring the charge back. But that's a very general description. But the key for you guys, the key component here is insanity as a defense, is attacking the mental capacity at the time the person committed the crime. Competency is to determine whether or not this person understands what they're about to go through in a criminal proceeding. So what happens after a verdict of guilty by reason of insanity is reached? There's a number of them. You could be absolved of all criminal responsibility. That's what happens. You're absolved of all criminal responsibility because you'd be guilty, like I said, guilty by reason of insanity. And generally you're committed to a treatment facility until free to return to society. And there may be a court hearing on that. So that's what happens. You don't end up with a criminal record, or a defendant doesn't end up with a criminal record. They don't have to go to prison. They just have to go and be treated. Can someone be temporarily insane? Yes, at the time of the offense. Not everyone remains insane afterwards, especially after they get treated or evaluated. Actually, I think this was what happened in Lorena Bobbitt's case. She was treated for that particular incident, and then she's fine. I think she's gone to write books, and they've made movies about her story and so forth. You may already be familiar with it. But I represented an individual who was arrested for a crime. It was a big theft crime, and I used this defense and I was successful in using the insanity defense, but I had I had so much evidence in our favor. I was very surprised that the prosecution still went forward, because at the time of the incident, the client just kind of went off and he was a business owner. He would not think that he was a business owner, had lots of businesses in the area, in Vermont, I should say. And he just had a breakdown, and you could tell it was coming, listening through his voicemails in that 3-day, it was only 3-day period of time. His family was concerned about him. They actually went to court and got a court order, and it's very hard to get a court order to have you removed out of society because you're acting extreme, dangerous, and doing odd things like stealing cars. That's what he was doing. And the court committed him, and then he had a psychiatrist assigned to him, and he had already had some issues in the past. It wasn't just it happened, but I was able to prove at the time of the offenses that he was being charged with, he was deemed manic. So, and afterwards, and by the time we got to trial, he was recovered and seeing his psychiatrist and back to business. So the court ordered him to do an evaluation. He did an evaluation, but he was deemed okay, and it was over. That's it. So yes, temporary insanity can exist. It's not a forever deal. So make sure you watch the videos that are also linked to this, and we'll cover our last bit of defenses.